Hello, my name is Guillermo Perez. I'm a labor educator with the United Steelworkers Education and Membership Development Department. I'm going to take a few minutes to talk to folks today about 4 important topics for union activists, especially shop stewards. They are in order: the special status of union reps or shop stewards, the right to union representation in an investigatory interview. We call these Weingarten Rights. The duty of fair representation, the legal duty that the union owes its members and that union activists have to comply with, and the union's right to information. So we're going to start with the special status of union representatives or union stewards, as they're sometimes called. It's very important that folks understand that as a rank and file employee who becomes active in the union, when you take on an official position as a steward or a union representative, you're no longer acting as an employee in those particular situations. You are equal with management. And this means that there are things that you can do as a union activist and representative that you wouldn't otherwise be able to do as an employee. And we call this the equality principle. So what it means is that when you're acting in your capacity as a union representative, you are equal with management. Now, what does that mean? It means that under the equality principle, union reps can act, when they're acting as union representatives, they are equal with management. They're entitled to ask for information. You're entitled to raise your voice. You're entitled to refuse to agree with management. And you're entitled to stop a discussion, ask for a caucus in the context if you're representing a member. Also, as a union representative, you are then protected when you're in the course of doing your job, which is to say when you're investigating grievances, when you're asking for information for a possible grievance, when you're presenting grievances, and when you're representing other employees in front of management. These are sort of the classic things that we do as union representatives, and in those situations, we are not employees, we are union reps, and we are equal with management, and so we are protected then against any kind of retaliation on the part of management for our doing our job. Now, all that said, that does not mean that there aren't limits to this protection. If you use excessive profanity in a meeting with management, you might not be protected. If you use racial, ethnic, or gender-related epithets, you probably lose the protection. And certainly if you make threats of violence, direct or indirect, you are not going to be protected. So yes, the equality principle is important, it protects us, but it does have some limitations, and you want to always be careful not to cross that line. The other thing you should keep in mind with respect to, there's a phrase that we use, obey first and grieve later. When you fail to do that as an employee, you could be susceptible to insubordination charges. But when you're acting as a union representative, you're not required to obey any commands of management because you are equal with management. So again, keep this in mind. It's one of the great things about being active in the union is that when you are acting as a union rep, you are equal with management. You're entitled to ask for information. You're entitled to defend your position. You're entitled to do your job to represent and advocate your members. Okay, so now let's talk about something that we call Weingarten Rights. This is the right of your members to have a union representative present in what we call an investigatory interview or an interrogation. This is part of the disciplinary process, and it's a central role that union stewards play in the union, and specifically for our members. So first, it's important to understand this right to have union representation comes from a Supreme Court case called the NLRB versus Weingarten Incorporated. And it's, as I said, it establishes under the National Labor Relations Act that workers in unionized workplaces have a right to union representation in a disciplinary interrogation. Now, what is a disciplinary interrogation? First of all, it's a conversation with management in which questions are asked of the worker in order to obtain work-related information. If there are no questions being asked, then it's not an interrogation, and Weingarten doesn't come into play. 2, you need to have, or I should say the worker needs to have a reasonable belief that his or her answers could be used as a basis of discipline, discharge, or some other adverse action. So these are the 2 things you need to have: questions being asked by management and a reasonable belief that discipline or some other form of adverse action could flow or follow from the responses given to the questions. If you don't have both those things, then you don't have an interrogation that triggers Weingarten Rights. So what does not constitute a disciplinary interrogation? A casual conversation between workers and management, even when it relates to work performance and questions are being asked. So a staff meeting where a new policy is being discussed, that won't trigger Weingarten Rights, basically because there's no reason to think that discipline is going to follow from anything that's said at that meeting. Also, an announcement that disciplinary action has already been decided. So if someone's called in and told, well, we're going to give you a suspension for 3 days for doing this thing, you'll notice there are no questions being asked. A person's just being told, here's what management's decided to do. So here again, Weingarten wouldn't kick in. That person wouldn't have a right to have a union rep present unless there's something in their contract that says that a rep should be there. Now, it's important to understand, though, that even casual conversations can suddenly become investigatory interrogations should management's tone take a hostile turn. So remind members, when in doubt, invoke your Weingarten rights. This is really important. If any member has any reason to be uncomfortable in a situation with a supervisor or management rep, they should invoke their Weingarten rights. And in many cases, they'll get a union rep, even though technically maybe they're not entitled to one. And the union should be giving its members Weingarten Rights cards, these cards that explain what their rights are, so that people can even give supervisors or management their card invoking their right to have a union rep present. Why should a member invoke their Weingarten rights? Well, first of all, the steward can serve as a witness in a future arbitration hearing. It's good to have a witness present should the discipline, or should there be discipline, or should the union appeal the discipline, then what gets said in that interrogation could come up in a hearing, and it's good to have a witness there. The steward can also check aggression, intimidation from management. If management is asking inappropriate questions, if they're basically just trying to intimidate the person or scare them, it's good to have a rep present to say, that's not appropriate, let's stick to the topic at hand. Also, it's key for them to make sure that they know what the investigation is about so that management doesn't go on some fishing expedition to find something to get this person on. The steward can also counsel the worker against offering too much information or making a problematic blanket denial. So we always prep people ahead with these interrogations, telling them just answer the questions asked and don't elaborate anything more than that. Also, similarly, we may have people who will say, well, I am not going to go in there and confess to anything. Sometimes we counsel people and say, look, they've got videotape, they have all kinds of stuff. What are you going to accomplish by going there denying anything? You could get hit with a dishonesty charge in addition to other things. So part of having a rep present is basically sort of getting you a lawyer, in a sense, to sort of counsel you on what's going to be the best approach in this disciplinary interrogation. Also, the steward can keep workers' emotions in check to avoid overreacting. Sometimes people get very emotional in these kinds of discussions. They could end up maybe saying some things that they really shouldn't say and get themselves in deeper trouble. So having a steward or a union rep there really helps check that and assist the person through what could be a very stressful encounter. There are 5 steps that we generally ask union reps to go through when they represent somebody in these situations. First of all, you want to make sure that you identify to management you're there as the union rep so that you are equal with management. Remember, we have this equality principle. You want to ask why management is conducting this interrogation. You can't really represent somebody unless you know what is it that management is investigating. If they refuse to tell you, then you should tell them, well, we'll grieve that or we'll file a charge, because I can't represent a member unless I know what it is you're investigating. So you insist on knowing what. You don't have to know everything, but you have to generally know what they're investigating. And then you need a caucus to prepare for the interrogation. So if you don't have this information ahead of time to prepare the person, then you're going to ask management right then and there, I need a few minutes with this member to prepare for this interrogation. And then in the caucus, that's when you'll talk to the worker. What's your side of the story? Do you have a prior disciplinary record? What's your work record? If it is a situation in which there's no disagreement about what happened, but sometimes there are what we call mitigating factors. I've been late 3 times because I have car trouble and I've never had a past history of being late. We could use that to try to convince management that, this is not a serious problem and you shouldn't take any steps to impose discipline. So we try to prepare the person going into the interrogation, and in some cases we may actually argue with management, sort of present arguments to explain why something happened and maybe avoid a more serious sanction for that member. And then, of course, you're there to take good notes about what takes place, the date, the time, who was there, the questions asked, and the answers provided. So now I want to move on and talk about the duty of fair representation. So this is a duty that the union must uphold with respect to all workers covered under the union contract. It was first established by the U.S. Supreme Court in a case from 1944 called Steel versus Louisville and Nashville Railroad Company. And what it stood for is that union representatives, including stewards, are expected to hold a legal duty when handling contract grievances and disciplinary issues. This is the duty that the union owes its members when it comes to, as I said, enforcing the contract, usually typically through grievances, and then, of course, also representing them in the course of contract negotiations. Now, under this duty of fair representation, stewards or union reps must not conduct union business, that is to say, to do grievance handling and contract negotiations in a manner that sort of violates these three standards. They can't do their work in a way that is arbitrary, discriminatory, in bad faith, or in a perfunctory way. And I'm going to talk about what each of these things mean. Arbitrary means that it's not supported by fair or substantial cause or reason. You can't, for example, decide not to file somebody's grievances because you had a bet on the Super Bowl and they lost and they owe you money, and you're explaining to them, well, if you paid me the money you owed me, then I could handle your grievance, but you haven't, so I can't. That would be an arbitrary reason for not pursuing a grievance. Discriminatory means that you're basing your decisions on somebody's race, age, nationality, religion, or gender. Again, these things can't in any way come into play when we're looking at grievances or when we're considering proposals or negotiating a contract. You can't act in bad faith. Well, what does that mean? That means intentionally seeking to mislead or deceive a person about their rights under the contract. So again, if somebody has what looks like a valid grievance and I told them, well, there's some secret language in this contract that nullifies any grievance you might have, and of course there is no such thing, that's intentionally giving them bad information about what their rights are under the contract. And all of these things expose the union to liability. And then finally, perfunctory. Perfunctory means that you handle somebody's grievance, for example, in a superficial or cursory manner, which is to say, somebody comes to me with an issue, we think it's a possible grievance, we sit down and figure out what our time limits are, when we need to file this grievance if we're going to file it, and then let's say I promptly go on vacation, come back after the grievance was due, and now I have to tell that member, well, you might have had a valid grievance, but the time limits are up, and so we can't file it. That would not be a valid reason for not pursuing a grievance. That would be perfunctory, which is to say, I should have, knowing that I was going on vacation, I should have made sure that somebody would do the follow-up work so that if we were to file this on time, that it would be timely filed. So it's really a form of gross negligence in a way. So again, the duty is based on our not doing our work in a way that's arbitrary, discriminatory, in bad faith, or perfunctory. The bottom line with the duty of fair representation is that you must never allow your representation of an employee to be in any way influenced by their gender, their race, their nationality, their age, their religion, or their politics, their personality, or even their dues-paying status. All these things are not legitimate reasons on which to base any decisions with respect to grievances or with contract negotiations. Now, all that said, the union's not required to file a grievance every time a person approaches us, but we do have to base our decisions on the merits of and the facts and merits of that actual grievance and not let any of these other things come into play as far as our decision making is concerned. And if we do that, and of course, if we always notify people in a timely way about our decisions with respect to the contract, then we shouldn't run afoul of the duty of fair representation. So I do have a checklist that we always recommend that people follow. First of all being, investigate all grievances fairly and fully. Don't discriminate. Adhere to time limits in your grievance procedure. Don't play favorites. Represent everyone equally and in good faith. Prepare and present grievances in a professional manner. If you do those things, then you will not run afoul of the duty of fair representation. So finally, we have the union's right to information. This is a hugely important right that unions have under the National Labor Relations Act, and it's hugely important in both areas of administering the contract and negotiating contracts. So what is our right to information? Well, the obligation flows from the duty to bargain in good faith. That's the employer's duty to bargain in good faith with us includes their having to give us information that's relevant to our work as far as enforcing and policing the contract and negotiations. A refusal to provide information or unreasonably delay in responding violates the National Labor Relations Act. So under what circumstances can we request information? We can request information to police our contract, right? We can request information if we're investigating a possible violation of our contract. We can request information as a way of preparing for a grievance meeting. We can request information in order to decide whether to move on a grievance or to move it to a higher step or take it to arbitration. And we can request information if we're preparing for an arbitration. The information can be requested orally or by email or mail or simply attaching the information request to a grievance. It should state the information that's needed for a particular grievance, or it should also state that we don't have a grievance, but we are, in order to properly police our contract, we need the following information. So this is key. You don't have to file a grievance to have a right to information. You can ask for information as you're investigating a possible grievance as part of your duty to police the contract. The right to information is limited to matters that are relevant to grievance investigations or other union responsibilities. The information is relevant if it has some bearing on the issues that are involved. So let me give you some examples of the kinds of records and documents that the union is entitled to request. Accident reports, air quality studies, attendance records, contracts with customers, suppliers, and contractors, customer complaints, disciplinary records, drug tests, employer evaluations, investigative reports, job descriptions, material safety data sheets, overtime records, payroll records, personnel files, seniority lists, test results, training manuals, video surveillance tapes, wage and salary records, work rules. I mean, the list is, I mean, we can't even name everything. It's a very expansive right that we have, and it's hugely important to policing and enforcing our contract. So I would really urge you in any situation where you're investigating a grievance, think about the information that you need. And the other thing that you'll find often is that we can settle grievances by asking the right questions. Asking for the right kinds of information often leads to settlements. And this is also a hugely important right that we have as we go into contract negotiations, because we need lots of information in order to be able to negotiate in an informed way. And so this is a hugely important right that the union has, and I would certainly urge folks who are going to take on the task of enforcing our contract or negotiating a contract, always be aware of the information that you're entitled to and make good use of that. So thank you so much for taking the time. I hope this gives you a taste of the work that we do here in the Education Department. Thank you so much for stepping up and being active in your union, and I look forward to working with you in the future. Thanks again.